Okay.
2 years? Is that what you said?
Yes.
I'm just.
And was the value of that property under $200?
All right, folks, buckle up, because this one is not your typical larceny case. Today, we're diving into People versus Harold Dennis. At first glance, this looks like a standard plea hearing. A defendant accused of larceny under $200, a misdemeanor. But here's the twist. This isn't about shoplifting a candy bar or walking off with someone's phone. This case centers around a car, yes, a car, that the defendant held onto for not days, not weeks, but literally years. What starts as a deal between two men turns into a criminal charge when one side says enough is enough. Over the next few minutes, you'll see Harold Dennis admit to keeping the car, argue that he was working on it, and then try to frame himself as the guy just doing his best. The judge, however, is laser-focused on the facts: promises broken, property withheld, and a crime that dragged on for 2 years. The real question we'll be asking is, when does a handshake deal cross the line into larceny? Let's get into it.
Assistant Public Defender Jay Bellinger on behalf of Mr. Dennis. Mr. Dennis, can you please state your name for the record?
Harold L. Dennis. All right, I have before me a plea form that indicates that the defendant would be pleading guilty to an added count 2 of larceny less than $200 to 93 the offense. Upon his successful plea to that charge, count 1 would be dismissed. There is no objection to sentencing under 77(1.1).
That is our understanding of the plea, Your Honor.
I have him sworn.
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? You got it.
I do.
State your name.
Harold L. Dennis. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny less than $200. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $500, that would become the maximum fine. You understand all of that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Okay.
You understand that?
Yes.
Whoa, did you catch that? Harold just admitted he kept the car for not just a few days, not even a few months, but 2 entire years. Imagine handing your vehicle to someone for repairs, only for them to hold on to it for 2 years. That's not just bad business. That's straight-up theft in the eyes of the law. This is the exact turning point where the case escalates beyond a simple misunderstanding. What do you think, though? Was Harold genuinely dragging his feet on repairs, or was this just a cover story to hang onto someone else's property? Drop your take in the comments. I want to hear whether you'd consider this larceny or just a bad mechanic situation gone wrong.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay. Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty of this offense?
Yes.
On the date of August 19, 2023, at the location of 1150 Nash Avenue, Ypsilanti Township, Washtenaw County, State of Michigan, what'd you do regarding property belonging to Willie Rawls and Willie Rawls Jr. that makes you think that you're guilty?
Well, actually, I didn't do anything that,
Did you have an agreement with him?
yes,
And did you take his car as part of that agreement?
yes,
And as part of that agreement, you were to return that car within a specific amount of time?
yes,
And how long did you keep the car?
too long,
And how long is too long?
a couple years.
Here's where things get messy. The judge is cutting through Harold's story. 2 years of unfinished repairs doesn't hold up. Let's be real, no one needs 24 months to finish a job on a car. And remember, the owner repeatedly asked for the car back and was ignored. That's the nail in the coffin. When you keep someone else's property, deny their requests, and still insist you're working on it, the law doesn't see you as a mechanic, it sees you as a thief. I've got to ask, if you were in Judge Washington's shoes, would you buy Harold's excuse? Or would you see this as him just stalling to keep the vehicle?
Okay.
2 years? Is that what you said?
Yes.
I'm just,
And was the value of that property under $200?
well, it doesn't matter.
I understand for the purpose of the
But-
plea, Your Honor.
So how long were you supposed to have the vehicle?
Well, it wasn't a determined time, but supposedly till I finished,
Tell you what?
till I finished the job.
What job?
You were doing work
I
on the
was
car.
doing work on the car.
Oh, you were doing work on the car. And so then after you did the work on the car, you were supposed to return the car.
Well, I was not finished with the work on the car.
2 years later?
Well, yes, 2 years later. And
Did the owner of that vehicle have an expectation that you would turn that within a sufficient amount of time?
yes,
And did he contact the police as a result of you not returning the vehicle?
yes,
If I could briefly, were there multiple requests for the vehicle to be returned
Thank you.
that were not responded to?
yes,
And this, so that we're really clear, the work that you were supposed to do would not take 2 years to complete,
No.
would it?
no,
In fact, it should have been completed well before that 2 year period,
yes,
correct?
yes.
You just didn't do the work.
No, actually, I did do the work.
So, here's the big legal moment. The court accepts Harold's guilty plea. Count 1, dismissed. Count 2, he pleads guilty to larceny under $200, which caps out at 93 days in jail and up to $500 in fines, or even 3 times the property value if it's greater. But notice something critical. The actual sentencing isn't happening today. That'll be handled by Judge Washington at a later date after a pre-sentence investigation. Translation? Harold's fate is still hanging in the balance. Judges often weigh the defendant's honesty, cooperation, and criminal history before deciding jail time versus probation. Do you think Harold's story helps or hurts him here?
He did some
Okay.
work,
Well, I didn't have it finished,
and the
but,
vehicle was returned after a few adjournments of the PCC.
and it was returned fully finished and in excellent shape,
At 2 years older.
which I was trying to do in the beginning.
Well, here's what I do. Yeah, there certainly would be a higher charge I could accept a plea to, given the facts of this case. So with that understanding, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept a defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B District Court sentencing
July 3rd at 10 a.m. with Judge Washington.
July 3rd, 2025, 10 a.m.
10 a.m.
10 a.m. before Judge Washington.
Okay.
Bond will continue.
You need to contact 14B probation as soon as possible. And that's your sentencing date. Okay, and time. And that's the location.
Where am I standing?
You don't need to sign off on this one. That's just for you to keep for your record so that you know when to go to that court, okay? You can give me a call later. All right, take care of yourself.
Build the car in 2 years.
And that wraps up the hearing in People versus Harold Dennis. What started as a car loan deal spiraled into a larceny conviction. The judge wasn't swayed by the "I was just fixing it" defense, especially after hearing Harold admit to holding onto the vehicle for 2 years. With sentencing pushed to another date, the real consequences are yet to come, but today's plea ensures he's facing criminal penalties. This case is a textbook example of how blurred lines between personal agreements and property rights can land someone in serious legal trouble. Now I want to hear from you. Was Harold more of a shady mechanic or just someone who made a bad decision? Drop your thoughts in the comments. And if you found this breakdown as wild as we did, make sure to hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom drama every week.